The court is ready to hear argument in 2055 in the interest of DT from Hunt County and the 6th Court of Appeals District.
May it please the court, Ms. Ferguson will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. Good morning, your honors. It's an honor to be here this morning to present this case in front of you, and I appreciate the opportunity to do so on behalf of my client. Because this is a parental rights termination case, I'm just going to refer to my client as the petitioner or the mother and not make any reference to names or anything. This is a different kind of case. It's an interesting case for y'all because unlike, say, the case immediately before you or immediately prior to this one, this isn't a lot of disputed facts. This is a legal issue. And the issue here is, may a parent who has retained their own counsel in a suit brought by the state of Texas to terminate their parental rights, may they raise a claim of ineffective assistance of counsel against that attorney? There's a split in the lower courts of appeals. The 14th Court of Appeals in ERW is thus far the only appellate court in Texas to find that a parent has a right to raise an ineffective assistance of counsel claim when they have retained their counsel. I would submit to this court that the reasoning of the case in the 14th Court of Appeals, ERW, is persuasive and should be adopted for a number of reasons. First and foremost, if you look at the Texas Family Code, the Family Code gives you a statutory right to an attorney. It also gives you a right to a court-appointed attorney if you are indigent and cannot afford one. But the Family Code states very clearly that parents have a right to have an attorney represent them in a parental rights termination proceeding. Now, making a distinction between a court-appointed versus a retained counsel raises a due process concern because the interests at stake, whether the attorney is retained or whether the attorney is court-appointed under the Matthew versus Eldridge factors for due process, procedural due process analysis, the factors are the same.
Ms. Ferguson, can I ask you on that note, so are you proposing that we could rely entirely on the Family Code, or in particular the amendments to the Family Code provision that's at issue here, as the source of the right? Or if not, do we have to, does it derive from the Constitution itself or the statute alone?
I believe it derives from both, Your Honor, because as Troxel and other courts have made clear, parental rights are constitutional rights. And to have a constitutional right deprived by an action of the state implicates procedural due process. Procedural due process implicates the right to an attorney, and the state has recognized that there is a right to an attorney through the Family Code. And also in other decisions, I believe it was in, well, I can't remember the name of the court case, but it said that the right to a counsel cannot be waived by the parent.
So Ms. Ferguson, excuse me. Let's say if we were to find that the amendment to 107.013 was a notice provision in terms of the court's duty to inform the parent of the right to an attorney as it existed and has existed for many years under that statute. Would that affect your argument that we should treat ineffective assistance of counsel cases, whether they're appointed or whether they're retained, the same as they are treated in the criminal context? Would that affect your argument?
No, because although ERW took it on the basis of the amendment to the Family Code predating the decision in ERW stated that there was a right to an attorney in a parental rights termination case. So whether you say that that provision of the family code is merely a notice provision, or whether you say that it is actually establishing that right, it is still clear that Texas has recognized a right to be represented by an attorney in a suit when the state is seeking to terminate your parental rights. So the ERW, whether you look at it as just a notice requirement or not, the family code predating ERW still gave you that right to an attorney in a parental rights termination suit.
Ms. Ferguson, you noted for us in your brief that this is an issue, that where there's a conflict amongst the Court of Appeals. Have other states' high courts decided the issue one way or the other? What can you tell us about other jurisdictions and how they're treating this issue?
Other jurisdictions, to my knowledge, there's a split amongst other jurisdictions. I believe Tennessee has recognized the right to a court-appointed attorney, but I would submit that regardless of what other jurisdictions are doing, I think the mandates of our Constitution in the state of Texas and of course the due process clause of the federal Constitution, but for due course of law, would mandate that we follow what has been set up in the criminal sector. As this court is aware, the Court of Criminal Appeals in Ex parte Duffy eliminated any distinction between having retained counsel or court-appointed counsel in raising a claim of ineffective assistance of counsel on appeal. And I'm arguing that that analysis, that constitutional analysis of due process rights, there is no meaningful distinction or reason not to apply it here. You are in the same scenario under the Matthews versus Eldridge factors. And those factors are that you have an action, you have a private liberty interest at stake, you have the government seeking to impact or terminate that private interest, and then you have a process that has to be determined as to whether or not the process is fair. And there wouldn't be a question, and I think this court would agree, that had my client had a court-appointed attorney, and same facts, if this counsel had been court-appointed rather than retained, the Court of Appeals in the Sixth Court would have entertained and analyzed and reviewed her claims of ineffective assistance of counsel.
And those were addressed in the Court of Appeals, not here, but are the only two I saw in the briefs in the Court of Appeals were that the lawyer did not have a witness list and didn't preserve insufficiency of the evidence. Were there other complaints?
Not in the brief to the Court of Appeals, but Your Honor, if I may please correct you, the Sixth Court of Appeals did not consider the ineffective assistance. They said, and I can quote the provision, that a parent who hires their own attorney cannot raise an ineffective assistance of counsel challenge, therefore her point is overruled.
No, I didn't mean to suggest that the court did, but the mom's brief in the Court of Appeals alluded to two specific instances of ineffective assistance, no witness list and no preservation. But were there others?
There were, Your Honor, because this is an unusual situation. The retained counsel who intended to represent the mother on appeal was subsequently suspended by the state bar or disbarred, I'm not sure which, in the middle of the appeal, which caused the Sixth Court of Appeals to have to put the whole matter on hold, refer it back to the trial court, and apply court-appointed counsel for the mother to then proceed forward with the appeal. So there are those issues too. And again, the issue that I'm raising and that I'm arguing is not that the mother in this case, the petitioner, necessarily wins on an ineffective assistance of counsel. I am in no way implying that due process says that you have to be able to win.
Why should we decide what is a very significant issue if there's no way she can win?
because it impacts not only her rights, but it impacts the rights of other parents in Texas, and it goes to the statutory scheme of the fairness, and it creates a substantive due process issue if you do not grant equal right, because you are in effect saying that if a person hires their own attorney, they have fewer protections than someone who is court appointed. Again,
Ms. Ferguson, say we agree with you on that point, that the applicability of, that Strickland applies whether counsel is appointed or retained. The department responds that there is no evidence here to demonstrate that the second prong of the Strickland test has been met, that the outcome would have been different had the mom received reasonably professional assistance. So what do we do with that piece of it where they say, following up on the Chief's question, where they say, look, you know, even if you were to apply Strickland here, the outcome would not have been different. And so the ineffective assistance challenge lacks merit.
If the ineffective assistance challenge ultimately lacks merit, that again is a different question from whether my client has the right to raise that claim and whether other similarly situated parents in the state of Texas whose rights are being terminated by state action have the right to raise that claim. So it's beyond just the specific limited facts of this case, because as I've stated and I conceded in my brief, the parent petitioner mother may not prevail, but that is not what the due process analysis.
So you're asking us to answer both questions. So for example, if we were to say that Strickland applies, rather than remand it back to the lower court to make that determination, that we could make that determination that even though Strickland applies, she's not entitled to a remand to the trial court now.
I wouldn't, not a remand to the trial court, I would remand it to the appellate court.
No, I know. I mean, eventually down to, for her to be able to reassert her defense. But yes, you're right, to the Court of Appeals for that determination. Yeah.
Yes, Your Honor. She would be able to raise it and have it argued and considered by the Sixth Court of Appeals to make the Sixth Court of Appeals render a decision so that she could then look at the analysis that the Sixth Court of Appeals made in making that finding that she didn't sufficiently prove her insufficient or ineffective claims, and then bring it up for this court to give a further review to make sure that the Sixth Court did it properly. I mean, I understand it sounds like a lot of procedural gobbledygook and hurdle jumping, but it's again, we're talking about a constitutional right that I don't think anyone here, and I don't think the department disputes, that parental rights are of constitutional nature. So we are talking about deprivation of constitutional rights. And my question and my concern and my argument is that there is no rational basis to distinguish between a court-appointed counsel and a retained counsel. The state of Texas in criminal cases doesn't do that. They got rid of that requirement in, I think, 1980 and said you can raise ineffective assistance. In the Ex parte Duffy case, you can raise ineffective assistance regardless of whether your counsel is retained or appointed because of the liberty interests and because of the fact that it is a state action. The court cases that say that the parent cannot raise an ineffective assistance of counsel claim in a civil suit are talking about civil suits that do not involve constitutional rights, constitutional dimensions. They are divorces, or for that matter, if this case had been, if the department had abandoned its pleadings for termination and had purely gone on managing conservatorship, then the constitutional right is not implicated. There would be no ineffective assistance of counsel right, because whether counsel was appointed or retained, there was still no constitutional deprivation. So the issue here is when it's seeking termination, there is no rational basis under the law to make a distinction between a person who retains counsel and a person who has their counsel appointed for them by the court, because the state is still the actor in this proceeding. The interests are still the same, and the rights that are being terminated are just as important. There's no distinction. And I would submit under the Eldridge factors, the Matthew versus Eldridge factors, that a parent should have the right to raise an ineffective assistance of counsel claim, regardless of whether they've retained or appointed their counsel. And I see I'm out of time.
Any other questions? Thank you, Ms. Ferguson. We'll hear from the respondent.
May it please the court, Ms. Safavi will present argument for respondent.
Good morning, and
You're muted, Ms. Safavi.
All right.
There you go.
all right, I apologize. So good morning, and may it please the court. As we've already been discussing, this whole case revolves around Texas Family Code 107013, which addresses the right to counsel for only a select few types of parents in termination of parental rights cases that are brought by the state. Here, the petitioner is not indigent and does not qualify under any of the other.
One thing I'd like to hear is your best rationale for why parties with retained counsel should be treated differently from parties with court-appointed counsel who are indigent.
Well, I would say that many of the cases out of Texas have treated the two differently, including from, and also there is no Sixth Amendment right to an attorney in these sorts of cases. There is a Sixth Amendment right to an attorney in criminal cases, which is why we treat them differently in criminal cases. That same rationale simply does not apply here. Cases repeatedly have said that you have to derive this right from a statutory or constitutional right, this right to appeal an ineffective assistance of counsel. We don't have that here, either under constitutional rationale or statutory, and that is why we treat them differently. I hope that answers your point.
Well, I mean, you can, the statute tells us, Family Code 107 tells us that a party with a court-appointed lawyer has a right to bring the claim. And in this case, in fact, the record tells us that this particular mother initially had a court-appointed lawyer. So initially, in the first part of the case, she would have had she kept that lawyer, she would have had a right to raise the ineffective assistance of counsel claim. But by changing over to a retained lawyer, she somehow lost the right. What is the rationale for that, other than to say that is how some courts have decided? What is the logic behind that?
I mean, all I can say is that the logic behind it is what the legislature has told us to do.
But the legislature says that she has the right to be represented by an attorney.
Well, and if you look at 107013, it does not necessarily grant the statutory right to counsel. We look to the plain language of the statute, as we all know, to interpret a statute. And under 107013, it talks about the title of the statute is mandatory appointment. And subsection A lists who gets appointed an attorney. Subsection A-1, when read in the context of the entire statute, does not grant everybody right to counsel. It grants these specific people right to counsel.
So when the legislature is telling courts to tell parents that they have the right to be represented by an attorney, that's false, as far if they can afford to pay for one.
Well, according to the statute, their right derives from their indigency or the other subsections.
So the court's just misinforming the party at the direction of the legislature.
I would say that the court is informing the parties in the context of the statute as a whole, as opposed to just taking out that one little piece. And of course, parents have the right to go and retain an attorney no matter what. You know, they can go and do that. That's also their right. So, I mean, I would go back to the fact that she has no statutory right to counsel. And if you just look at the way everything has been interpreted by different Texas courts, and if you just look at the simple statutory framework of 107013, to my knowledge, there is no other family code provision that provides her with a statutory right to counsel, and I don't believe the petitioner has provided her any.
Let's say if we agree with you, I'm sorry.
I was going to ask how you weigh the Eldridge factors in the analysis. So if you let's say we agree with you that the plain language of the statute doesn't provide for counsel to be effective. I mean, for a claim to be raised on ineffective assistance. But what about our cases that have said, a right to counsel would be meaningless unless we made it, we implied with it the fact that it was a right to effective counsel. Our cases have said that. How does that fit into the analysis?
Well, I would argue that we don't even get to the Eldridge analysis because those cases, for example, MS says the statutory right to counsel is meaningless without the effective, without effective counsel. And that's just not what we have here. And so we don't even get to the Eldridge factors at all. I'm sorry. Was there another question before I continue?
You should continue.
Okay, thank you. So the petitioner argues she did not receive due process. However, as she points out in her brief, the relevant inquiry is what process she was due and whether she received it. The process she is due is the opportunity to be heard in a reasonable time and a reasonable manner and a chance to hire her own attorney. And she was afforded all of that process. And like I said previously, she has relied on 2 criminal cases to show that this court should rule in her favor. But those were both criminal cases discussing ineffective assistance of counsel in the context of the 6th Amendment and writs of habeas corpus. And she doesn't acknowledge the Sixth Amendment deficiency or attempt to explain how we get from there to here. She also argues that because the termination of parental rights by the state involves a constitutional right, a party should have the right to effective assistance of counsel, regardless of whether counsel is retained or court appointed. However, we have many other types of cases which implicate constitutional rights where parties are not entitled to counsel. For example, private termination of parental rights cases, they're not entitled to counsel. And other issues like eminent domain, that is a state action, but you're not entitled to counsel there either. So in fact, the Supreme Court of the United States has discussed in Lassiter, due process is not grant you an absolute right to termination of parental rights cases brought by the state.
Nonetheless, even in 2014, my colleague, Justice Learman, described the termination of parental rights as a civil death penalty in KML, requiring clear and convincing evidence. Wouldn't due process compel effective counsel when we're dealing with something that's been described as a civil death penalty?
Well, I mean, we still have a civil death penalty in private termination cases, and we don't grant the right to counsel there either. In establishing paternity, you can trip up there, but you're not entitled to counsel necessarily there either.
But isn't there a difference when the state is bringing the suit, or is there?
I'm sorry, I didn't understand your question.
Is there a difference when the state is bringing the suit?
There is a difference because 107.013 only speaks to that. However, there have been cases, I believe ABB out of El Paso is a private case, but it still discusses the same rationale as we are discussing here today.
So is your argument that unless there's a constitutional right to an attorney in these types of cases, the fact that this type of a case is of constitutional proportion does not matter on this issue?
Well, I would just point the court to, many previous cases that say without a statutory or constitutional right to counsel.
Assuming that the statute doesn't provide for that right.
Yes, correct. Yes. Assuming that is true, which we argue that it is. She does not have the right to bring an ineffective assistance of counsel claim here. So, and I would point out that, again, as we argued in our brief, what she's essentially asking here is for this court to overturn quite a bit of precedent, which every case except for one case in this state has agreed She's asking us to overturn all of that based on a case that she essentially admits she cannot win. She's asking this court to take these facts where she all but admits she received effective assistance. And
Mr. Bobby, if you wanted us to affirm on that basis, did you need to raise a cross issue in this court?
I'm sorry, I couldn't understand you.
If you wanted us to affirm on the basis that assuming without deciding that there is a right to effective assistance of counsel, that she hasn't shown ineffective assistance, did you need to raise a cross issue on that in this court for us to consider it?
I don't know the exact answer to that. I can tell you that I brought up the issue of the fact that she's requesting an advisory opinion and can't win on these issues anyway, both in
Well,
the
it's not really an advisory opinion if she can't win, right? I mean, if she could win, then she wins one way and she doesn't win the other. So it doesn't seem like it's advisory. It's just a question of, do we decide it or do we have the Court of Appeals decide it?
And I understand that. It's just she's basically asking this court to rule on a hypothetical, where hypothetically, if she could win, if she had different facts, then maybe things would be different.
Let me ask you this: Can we don't have jurisdiction over factual sufficiency complaints? Can we decide whether she can show prejudice on a factual sufficiency complaint? Can we basically review the factual sufficiency of the evidence in this court to say, well, there was no prejudice under the second prong of Strickland because you wouldn't win a factual sufficiency challenge?
I'm not exactly certain, as I have not done any research on that. I would argue that if this court does not have jurisdiction to review factual sufficiency, I'm not sure how it could review the factual sufficiency at all, if that answers your question.
Well, we might, I'm just thinking it through. We might be able to if it's a legal question, but it's not something I've thought about, not something I noticed that the briefs address. So I'm trying to think that through.
No, Your Honor, that is not something that the briefs address. If you would like a supplemental briefing, I'm happy to provide it, but that's not something that we addressed.
That's fine. Thank you.
Okay.
Just to clarify, you're not asking for any greater relief than what was afforded by the Court of Appeals in this case.
That's correct, Your Honor. We're simply asking that this court uphold all of the precedent that has come before, which states that someone with a retained attorney in these sorts of cases cannot raise an ineffective assistance of counsel claim.
And that's why I asked you about a cross issue rather than a cross petition, because those are two different procedures. If you were asking for greater relief, you'd have to file a cross petition, and I understand that.
Yes. Yeah. All we're asking is that the Court of Appeals, the Sixth Court of Appeals, is affirmed. That's all we're asking for. So, and again, I do want to touch on the fact that she can't show that she received an effective assistance of counsel. She fails under both prongs, not just under the prejudice prong. She can't show that she received deficient performance. We don't have a record as to why her attorney made the decisions that her attorney made. And her attorney also participated actively in the entire case. They attended hearings, participated in voir dire, presented witnesses, made objections, did everything that an attorney is supposed to do. Also, her main issue seems to be that the attorney did not preserve sufficiency, whereas this court has already decided that the failure to preserve sufficiency in every case is not going to end up making an ineffective assistance of counsel claim. Also, under the prejudice prong, there's overwhelming evidence to support this jury's determination. We have a long history with the department, a long history of drug abuse that continued during the case. Her parental rights have been terminated to another child. There are several witnesses about her negligent parenting techniques. The child had bruises and an old crush injury once he was removed. The mother had not seen the child in months at the time that the case came to trial. So in essence, there's just no way that a sufficiency argument is going to get her anywhere because the evidence is just so overwhelming. So I would state that the Sixth Court of Appeals has followed all other existing Texas precedent in finding that the petitioner did not have the right to appeal on the basis of ineffective assistance of counsel, where there is no statute or constitutional right to counsel. The petitioner is asking for a dramatic departure for reasons that do not exist in this case and would not change the outcome and would not serve justice. The department would respectfully request that this court decline petitioner's invitation to upend years of Texas jurisprudence and affirm the Sixth Court of Appeals decision. And if there are no other questions, I will yield the rest of my time.
I have a question.
Yes, Your Honor.
Counsel, I understand the department would rather not have to deal with ineffective assistance of counsel claims as a litigation matter. But as a practical matter, is there any other reason, practical downside to allowing these sort of claims other than the fact that it's just an extra issue that you have to deal with on appeal?
Well, I mean, the downside would be that the legislature hasn't provided them with that right. So expanding the rights of under 107013 seems like the biggest downside here.
Any other questions?
Just following up on Justice Blacklock, I mean, it seems to me that because, at least in my experience over the years, retained counsel in these situations was the rarity. By far, most of the counsels are appointed in these situations. And so would the burden be much upon the department or upon the process if that were in fact the fact?
That is hard for me to answer without having, more precise figures about exactly how many retained or, how many appointed that we have. I will say that from my experience that there are quite a few appointed attorneys. That's the only real answer I can give for that. I apologize, Your Honor.
No, thank you.
Any other questions? Thank you, Ms. Savavi. Ms. Ferguson, I believe you have 5 minutes.
Thank you, Your Honors. I think as you made clear in your questionings of Ms. Savavi, the department's position really doesn't make a lot of sense because, first off, if you have the right to an attorney, if the court is required to inform you under the family code that you have the right to an attorney, why would they inform you of a right that doesn't exist? It doesn't say you have a right to a court-appointed attorney if you can't afford one, full stop. It says you have the right to an attorney. Then it says, if you cannot afford a court or a counsel, one can be appointed. So there's a two-step process. But secondly, as far as Ms. Savavi's argument about upending years of Texas jurisprudence, well, if the prior precedent is wrong or didn't use the correct analysis, which is what I assert in my brief, if you look at the case of ZC, which said there's no statutory or there's no right to raise ineffective assistance of counsel when you retain, they relied on Martin versus Martin, and Martin versus Martin was a divorce case. So there was no state action involved. If you go back and look at the cases, and I believe I outlined this in my brief, if you look at the cases that are relied on to say no statutory right to raise ineffective assistance of counsel in a civil case, that they all relate to cases where they are not state action and they are not of constitutional dimension. Ms. Savavi mentioned a private parental rights termination case. If Fred Smith wants to sue Lisa Jones and terminate her parental rights, that does not involve state action. That is two private parties utilizing the court system. But when the state of Texas comes in and says, we as the state of Texas are going to tell you, you can't have your child anymore, it is, as Justice Lerman said, it is the death penalty of civil cases. And
Ms. Ferguson, and certainly the court has acknowledged that. But when you say that Chapter 107 recognizes a right to counsel, I'm not following where you're saying that, because in 107.013A, it sets out the parameters of appointment for counsel. And in the amended version of the statute in A1, where it's telling the court what it needs to inform the parent of, it the plain language to me says one of the right to be represented by an attorney. It's not creating a new right. It's recognizing the rights that are already there. And the statute is about the duty to inform.
Yes, Your Honor, and that would be my point, is that if there's no right to a counsel, then there's no duty for the court to inform you of it.
Well, there are rights. It's just set out in A what those rights are.
Well, those rights are for indigent parents that it sets out. It
Right.
doesn't say, there's nowhere that says you don't have a right to a counsel. And in fact, as I've cited in my brief, you cannot presume waiver if somebody doesn't hire counsel to represent them in a CPS termination suit. This court can't just assume that they've decided to move along without counsel. The court has to make an inquiry and say, you have a right to an attorney. If you can't afford your attorney, we will appoint an attorney for you to represent you in these proceedings. You can't just assume, as in any other civil case, if a client wandered in on a divorce, again, Mr. Smith and Ms. Jones, if Mr. Smith comes into a divorce and doesn't have an attorney, he doesn't have a right to an attorney. It's number one, private action. Number two, no constitutional rights involved. Here we have state action and constitutional rights being terminated by the state.
Ms. Ferguson, is there a difference between being represented by an attorney and being appointed an ad litem to represent your interests? Are those different things under the family code?
I don't believe so, Your Honor, in practice, because the way you're deemed an attorney ad litem to represent the parent if you're appointed, but you are doing the exact same job as a retained attorney, appointed attorney.
Is that parent your client if you're an ad litem?
Yes. If I'm the attorney ad litem for the parent is my client and I have to represent that person. And I see my time is up. Does the court have any further questions?
Any other questions? Thank you, Ms. Ferguson.
Thank you, Your Honors.
The case is submitted and the clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.